everyone, and welcome back to IP Shots with another recent trademark infringement dispute. In today's video, we will discuss a very recent order passed by the Honorable Delhi High Court in the case filed by Singh law firm. This is an order dated 2nd of June 2021, and I have also given the link to the original order in the description of the video. So let's begin. Singh law firm filed an application under Order 39, Rule 1 and 2 of Civil Procedure Code seeking protection of their mark Singh and Singh. So the plaintiff's case was that their law firm Singh has been using this name since its inception in 1997, and their firm has been functioning in various areas like commercial laws, arbitration, and intellectual property rights. The counsels for plaintiffs stated that they came across the defendant's mark on a social media post, and on further research, it was found that one of the defendants was an ex-associate of the plaintiff's firm. As you can see both the marks on the screen, the left one depicts the one of the plaintiff and the right one is the defendant's mark. We can very evidently observe that both the marks are deceptively identical and similar to each other. The defendant has also adopted a very similar color scheme to that of the plaintiff's mark. So the case further proceeded by plaintiff proving that prior to May 2021, the defendants did not use the name Singh as a part of their trading style and ran their individual legal practices under the name and style GSC law and KSK law. So the absence of the word Singh in the trading styles or names of any of the defendants shows that the defendants deliberately changed their name with full knowledge of the plaintiff's rights in the mark. Plaintiff submitted that it was a very clear case of infringement under Section 29 Clause 3 of the Trademarks Act, as there was a presumption of confusion. Also, the plaintiff being an ex-associate of Singh law firm shows the malified intention of them in cashing upon the enormous reputation and goodwill that the mark Singh enjoys and carries. On the other hand, the defendants contended that the firm is registered with a law society in Canada, Ontario, and the areas of practice of their firm do not overlap with that of the plaintiffs. They stated that their practice is confined only to Ontario, and as per law, they cannot practice beyond that jurisdiction. Further, they relied upon Section 35 of the Trademarks Act and contended that Singh, being the part of the name of one of the defendants, entitles him to use that word as a part of his firm name. The court, after hearing both the parties and both the sides, concluded that the facts demonstrated that infringing marks were identical, and just because the defendants contended that they are currently practicing only in Canada, it cannot be the sole ground to refuse injunction. Also, the plaintiff's law practice is not only confined to India but has a global reputation, and thus the geographical boundaries cannot be a limitation to the reputation of a law firm. Therefore, the court held that there is a strong possibility of confusion as the two marks are predominantly identical, and so there exists a very strong likelihood that the law firms or the clients will believe that the defendant's mark is another branch of associate office of Singh. So an interim injunction was granted against the defendants, and they were also ordered to suspend the domain name singhllp.com. So this was another case where the court granted an interim injunction against the infringers. Thanks for watching. Subscribe IP Shots and keep yourself updated. Do not forget to press the bell icon for regular updates. Take care, stay safe.